delegates for our webinar series. And now I request our President, Sir, Dr. V.V. Chinevalar, Sir, for giving a welcome note, Sir.
Hello. Hello.
Yes, sir.
Can you hear me?
Yes, sir.
Good evening to one and all, and welcome to Dr. Shivakumar Utture for giving me addressing a wonderful this one excellent topic, consumer protection then and now. So Dr. Madhusudan Karinur has chosen a very good topic. So let it enlighten. Dr. Shivakumar is going to enlighten about it. So it will be beneficial for most of the practitioners of Karnataka state. So I welcome Dr. Shivakumar Utture to start the program. Thank you.
Thank you, sir. Now may I request our Honorary State Secretary, Dr. Suriraju, sir, for IMA prayer and salutations.
ಎಲ್ಲರಿಗೂ ವಂದನೆಗಳು. ಮತ್ತೆ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಪ್ರಾರ್ಥನೆ, ಎಲ್ಲರೂ ಸಂತೋಷವಾಗಿರಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಾಗಿರಲಿ, ಎಲ್ಲರೂ ನೋವಿನಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲರೂ ದುಃಖದಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲ ಆಸೆ ಆಮಿಷಗಳನ್ನು ಮೀರಿ ಗುಣಪಡಿಸುವವರು ನಾವಾಗಿರಲಿ. ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ, ಮತ್ತು ಅದರ ಪಥವೇ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆಯ ಮಾನ್ಯತೆ ಪಡೆದಿರುವ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತಿದ್ದೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನೂ ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. IMA ಚಿರಾಯುವಾಗಿರಲಿ. ವಂದನೆಗಳು.
Thank you, sir. Now may I request our chairman of IMA KPPS, Dr. Madhusudan Kariganur, for the introductory note on the topics, today's topics. Sir, unmute madbek, sir.
Yeah. Good evening to one and all. Good evening to all the esteemed members of IMA Karnataka State Branch and also members of IMA headquarters who have joined us. On behalf of IMA KPPS, I welcome our State President Dr. Chinevalar and Honorary Secretary Dr. Suriraju, and also seniors like Dr. J. Sharanappa, our Secretary Prasad, and all other esteemed members. And through KPPS, this is the first guest lecture that we have arranged to make our members aware of the Consumer Protection Act, which is dangling and on our profession. And it is very important to know that what constitutes the medical negligence. As doctors, we owe our certain duties to our patients who definitely come to us for illness treatment. A deficiency of in this duty results in negligence, and the basic knowledge of how medical negligence is adjudicated in the various judicial courts of our India will help a practitioner to look at our profession without any undue worry about facing litigations for the alleged medical negligence. Keeping this in view, our IMA KPPS is committed to protect our IMA KSB members against the wrath of the compensation that has been invited. Keeping in this view, we have invited our national leader and also well-learned Dr. Shivakumar Utture, sir, to guide us what is happening in this act. Now, over to Dr. S.M. Prasad, our KPPS Secretary, to introduce our guest speaker.
Thank you, sir. So now we will go ahead with the topic. So we are honored to introduce our guest speaker of today, Dr. Shivakumar S Utture, Consultant, Department of General Surgery in Sushruta Hospital at Dadar, So he's having lot of achievements and also accolades to its credit. So I would like to introduce very shortly. So it is my duty also. So he was the National Medical Commission Medical Advisory Council and President of Maharashtra Medical Council. And he's also a laparoscopic surgeon in Mumbai. And he's having a lot of degrees to his credit. Like after MS, he has done FICS USA and FMAS also. Previously, he has served as professor of surgery and unit head at the Grand Medical College, JJ Hospital. Also, he was a fellow of International College of Surgeons, fellow of Minimum Access Surgeons, and also he was selected for the post of chairman AKN Sinha Institute of Medical Education Research, IMA headquarters for 2015 and 16. He was also executive committee member and chairman of the finance committee of Maharashtra Medical Council, and he is also recipient of BBMG Mahatma Gandhi Award at British Parliament, London in 2020. And also he was IMA National Corona Award the Warrior Award in 2020, and also he has been with the orator for so many, and also he has been awarded Ati Visishta Parvaran Mitra Award in the field of medicine, public health IMA National Award for long service to IMA in 2015. And also achievement award is there, so many distinguished services he has done, and also he is very prominent and popular in among the IMA members as well. So over to Dr. Shivakumar Utture sir for the deliberation, sir.
Yeah, thank you. Thank you very much, Dr. Prasad, sir. And I think it's a pleasure giving a talk to IMA Karnataka, which basically is my hometown, though I'm now settled in Mumbai. Good evening to you, President Sir, Dr. Chiniwalar, Secretary Sir, Dr. Suri Raju, and my friend, Dr. Madhusudhana, Chairman, Dr. Prasad, Secretary, and I see some of my very close friends. Dr. Pawan is there, Dr. Venkatachalapati is seen, and of course, Dr. Anuradha Madam. Then from Maharashtra, I'm seeing Dr. Hosi Kapadia is there, and is the National Vice President sitting, and Dr. Dinesh Thakre sir is also there. So it's a great pleasure talking to such an august audience. And the subject which has been given to me is something which has been bothering IMA members for the last so many years. For more than 2 decades, we have been fighting. Can you see my slide, please?
We can see, sir. We can clearly see.
Yeah, so I can go ahead. Thank you. So we have been fighting this problem of CPA for almost 2 decades at different fora. Some places we got some success, but majority of the time we were unsuccessful. So, and it is, with the new CPA Act of 2019, again, there was a lot of confusion amongst the medical fraternity. Do we come under the CPA Act or not? So I'll just try to go through whatever the changes have taken place, mainly as far as the medical fraternity is concerned, in this Consumer Protection Act and how it affects us. Let me tell you, many people ask me, compared to the old CPA Act, how is the new CPA Act? I would just say in one word that as far as we medical people, at present at least, as far as we medical professionals are concerned, it is like from going from a frying pan into the fire. So we are worse off in the new CPA Act as compared to what it was in the 1986 Act. So as all of you are aware, our name was not mentioned in the old CPA, in the CPA Act of 1986, but it was by the Supreme Court judgment in the VP Shanta case in 1995 that the Supreme Court said that the medical profession does come under the Consumer Protection Act, though the name has not been mentioned. So what did the Honorable Supreme Court? It analyzed and interpreted Section 210 of the Act in IMA versus VP Shanta 1996 to read medical services in the Act. And what they said is, this service that we are giving, does it come under CPA or not? And they gave a clarification that service means service of any description. The word any is extremely important, which is made available to the potential users. Again, potential word is very important. And then it talks about what facilities are included. And if you see in those facilities, now this is the 1986 Act that I'm just showing you. If you see the facilities, nowhere is the medical fraternity written over there. And there is an exclusion clause stating that, but does not include rendering of any service free of charge or under a contract of personal service. So these are the only two things which was excluded as far as the CPA is concerned, as far as the medical profession was concerned. So when they read through the whole thing and they gave a clarification, what did they say? So the Supreme Court said that this act can be split into three parts. One is the main part, the inclusionary part, as far as the service is concerned, definition, because that is where the whole issue started of are we there under the Consumer Protection Act or not? And then, of course, the exclusionary part. So in the main part, as far as service is concerned, and it is defined, it says that any is what is used, the word as I have already told you, and potential users. So any description and potential users, they said under this, definitely the medical fraternity will be coming. Then as far as the inclusionary part is concerned, it has said, it has given multiple, finances, insurance, transport, etc., etc. Though the word medical fraternity is not over there or medical service is not over there, in the exclusionary part, they have said that excludes rendering of any free service of charge or under contract of personal service. So because in exclusion, there was no mention of the medical fraternity, the court said that the medical fraternity will be coming under or services will be coming under the CPA Act of 1986. So the emphasis was mainly placed on these two words, any, to read in the intention of the parliament to include medical services. So when they said at that time that when you say in that service, when it is written that the word any description, service of any description, the parliament has included the medical services. That is what the diktat was given as far as the Supreme Court was concerned. And because of that, unfortunately, we came under the ambit of the CPA Act 1986, though the word medical services were never mentioned in the main act at all. What happened? The whole scenario as far as the medical field is concerned, or the way we practice concerned, completely changed in 1995. And pre-1995, that means pre the VP Shanta judgment, which was given by the Supreme Court, and post-1995, there was an increase of 2,300% in litigations against doctors since that judgment. So you can imagine how detrimental was this Supreme Court judgment as far as how we used to practice before 1995 and how we are practicing today post 1995. Then, of course, over the years that 1986 was going on, and in 2019, because there were some issues which were there, which the central government felt that the consumers were not protected properly under the 1986 Act, it was in August 2019 that this new Consumer Protection Act of 2019 got its assent from the President. And you can see the whole, it's a huge document which is there. It is available online also. You can easily go through that. And then in July 2020, to be specific, on 15 July 2020, the notification of this act came into existence. That means as of 2020 July, no more than 1986 CPA would be in place because that is abrogated completely, and the new act has come into place as far as all consumers are concerned. I'm not talking only of the medical fields, but all consumers are concerned. And what happened? Let me just go into the past history before the notification of this act or before the assent was given by the president. So there was a Consumer Protection Bill 2019, which was, there is always a bill, and which is presented, and once the bill is passed on the floor of the house, it becomes an act. So in that bill, which was introduced in the Lok Sabha on 8 July 2019, the then late Mr. Ram Vilas Paswan, who was the Minister of Consumer Affairs, this bill was passed in the Lok Sabha in July 2019. And in that old bill, if you see, there was, and the word healthcare was mentioned in section 242 of the CPA bill 2018 after the word telecom. So healthcare for the first time was introduced as compared to the 2018, the 1986 CPA bill. In 2019 bill, it was introduced healthcare. But then there was a hue and cry everywhere, especially all the medical, fraternity was up in arms for having included, because we were fighting that, we were there included in the CPA in 1986 because of the court judgment, though the law did not say that, and it was not passed on the floor of the house. And because of that, healthcare was, though it was included in the bill, which was passed in the Lok Sabha, but when it was introduced in the Rajya Sabha, there Mr. Ram Vilas Paswan gave a statement saying that he would remove healthcare from this bill before passing this, bill and making it into an act. And why he wanted to remove it is, during the debate which was there, and many of us must have heard that debate. The reason that was given, that because the whole medical fraternity has become defensive due to the fear of CPA, and the inclusion of healthcare in section 210 of the act by the judgment of IMA versus VP Shanta of 1996, it was pointed out by the members, by all the other members of the house, which it has resulted into great distortion of practice of medicine. Hence, it was excluded from the 2019 bill when it was drafted. This was stated on the floor of the house by the Honorable Minister, the late Mr. Ram Vilas Paswan. So basically what it shows is that it proves that there was an intention of the parliament to keep healthcare professionals out of the ambit of the CPA. So we were very happy when we heard him on the floor of the house when he said that, and we were very sure that we were out of the CPA ambit. But was it that? Because ultimately, when the act came into place, there was a little bit problem as far as the act is concerned. So do we really come under the act or not? Now, there are two aspects which clearly in the act states that why medical negligence does come under the ambit of the CPA 2019 Act. One is, these two words are very important: contract of service and contract for service. What does the contract of service say? That there is a master and servant relationship between the two parties. So to give you a simple example, you have a house servant in the house. There is a contract between you and the house servant, but this is a master servant relationship. So this is contract of service, right? This does not come under the Consumer Protection Act. Please remember this sentence, what I'm saying, because in the further slides, it will be coming. What is the importance of this? Whereas the medical fraternity was basically put into the contract for service aspect. And because it was put into the contract for service, in which the service provider is not subjected to a detailed direction and control by the person who is taking his service. And therefore, this professional technical skills and his knowledge that he uses is at his discretion and not in the power of the person who is asking for this service. So this two differentiations of simple words, like when we are using it in colloquial languages, we don't bother contract of service or for service, but this was interpreted differently by the court of law. And this is where we find ourselves under the ambit of the CPA Act. In the whole of the document of 2019 Act, as far as the Act is concerned, nowhere do we find the healthcare services written over there in black and white in that Act. But unfortunately, in the rules which came out in 2020, and there is one aspect in the new Consumer Protection Act of mediation, and in that, if you see that it dictates under Rule 4 that matters relating to proceedings in respect of medical negligence resulting in grievous injury or death should not be referred to the mediation cell. So this is the only place that we find in the whole of the CPA that the healthcare has been mentioned over there, unfortunately. And because this has been mentioned, we do come under the ambit of the new CPA 2019 Act. Another thing that has been added to that is the definition of the unfair trade practices. And this is very important, especially why I'm pointing this out for the medical fraternity is what comes under the ambit of unfair trade practices and under which you can be tried in the consumer courts is a failure to issue a bill or receipt. Now, this is very, very important, especially for my friends who are in the consultings or the family physicians. Very rarely ever we give, unless the patient asks for it, we ever give a bill for whatever we have, whatever consultation we have done. So that can be pulled up, unfortunately, as unfair trade practices. Another aspect is disclosure of personal information. This is there in our ethics also, in the code of ethics, which is there, where personal information cannot be disclosed as far as the patient is concerned, even to the close relatives of the patient, unless the patient gives you the permission to do so. So these two aspects which are there in the code of ethics has also been mentioned in under the unfair trade practices as far as the CPA is concerned. So what has been written in the new 2019 Act? Here again, the service has been defined, and clearly it mentions that unlike what it was there in the old Act, what I have pointed out in blue, but not limited to, has been added over here. And that gives a wide ambit of what facilities and what services can come under the CPA Act. So what it says is service means service of any description which is made available to potential users. So any and potential, these two words has again been repeated in the new Act. But what is added is but not limited to, which was not there in the old Act. So the provisions have been given like insurance, transport, finance, and everything has been given. Again, here, healthcare has not been mentioned. But because of these words, but not limited to, unfortunately, healthcare comes under the contract and comes under the Consumer Protection Act. So what is the exclusion clause remains the same. Unfortunately, though Mr. Ramvilas Paswan says that he wanted to remove the healthcare sector from the Consumer Protection Act, unfortunately, in the exclusion clause, it is again the same thing has been repeated, but does not include the rendering of any free service of a contract of person, charge, or under services. So, if he wanted to really exclude us. Now, I don't know if this has been done by the ministry or it has been done by the, the secretary level, where the word healthcare has not been put in this exclusion clause. If that had appeared in this exclusion clause, we would have been away from the ambit of CPA. Then again, deficiency has been, defined over here, and what it says is deficiency means any fault, imperfection, shortcoming, inadequacy in the quality, nature, and manner of performance which is required to be maintained, comes under the Consumer Protection Act. So any act of negligence, or it can be omission or commission, which again, as all of you must be aware, the question of omission and commission comes in a big way as far as ethics is concerned in medical practice, and deliberately withholding of relevant information. This has been mentioned in deficiency. So if you do not tell all the information to the patients, and this is where the question of consent comes into play. So in your consent, if all relevant information is not given to the patient, again, you can be hauled up by the patient under the CPA. So it does not mean that only when there is an injury, you can be hauled up even if you have not given the relevant information. And that is where informed consent is the most important aspect as far as future medical practice is concerned. Now, that is a big chapter unto itself, and it's a 1 hour lecture, but we have to see to it that henceforth we take informed consent and not real consent that we used to take up till now. So let us see what is the difference between, what was the 1986 Act and 2000. And this is a chart which tells you all the difference in one chart as far as the health sector is concerned. So COPRA, as it was known as in 1986, it was nothing but same thing, Consumer Protection Act, and the CPA of 2019. What are the differences? As far as e-commerce is concerned, as you know, in 1986, there was no e-commerce. It has been defined under under the ambit of the CPA 2019. And here is where our telemedicine comes into play. So whatever you do, even on telemedicine, will come under the ambit of e-commerce, and the patients can pull you up or haul you up for, under the CPA. The new thing of mediation has been allowed. So mediation is nothing but settlement, which is allowed as in common terms, we say as out of court settlement as far as, the other civil courts are concerned. So this is also allowed under the CPA now. And there is again, the whole chapter is written on mediation, how the mediation will take place, who will be the mediator over there, how will you have to first sign before you go for the mediation, and how once the mediator gives his report, it will be binding on both the parties. So this aspect of mediation is another thing. And this is where nowadays even your lawyers will tell you that if there is a case against you in the Consumer Protection Act and prima facie there is some negligence which you have done, it is better to go for a mediation and settle the issue than wait for the court, that is the consumer court, to give their judgment, because as you are aware, nowadays the consumer courts are giving judgments not in lakhs but in crores, as we are seeing in the few recent judgments, unfortunately, which are coming. Then, of course, the product liability is also there, that the consumer can go to court saying that he has been harmed because of either the service taken from the doctor and there has been some bodily harm or whatever, mental harm or something like that, for which again the court again will enhance the compensation to be given to that patient. Pecuniary jurisdiction has completely changed. If you remember, there are in the old COPRA also that there was a district forum, state forum, and national forum. And it was said that district forum will hear cases where the patient has asked for a compensation of less than 20 lakhs. The state will hear where the compensation asked for is 20 lakh to 1 crore. And the national is above 1 crore. Now what has happened is they have completely changed it to the district commission will hear cases less than 50 lakhs of the billing that you have done. So remember the difference. In the old one, it was the compensation. In the new one, it is the billing. And even that has been enhanced to 50 lakhs district commission. State commission is 50 lakhs to 2 crores and national commission is more than 2 crores. In the original act, it was up to 1 crore in the district commission, but then there has been an amendment subsequently after that, and the amendment talks about district commission having only 50 lakhs. That means what is going to happen is if your billing is less than 50 lakhs, the case will go to the district commission. So 99% of the medical, cases which go to the consumer protection will be in the district commission today. Because obviously, very rarely ever, if it's a corporate hospital only, then it may go above 50 lakhs. But majority of our doctor-owned hospitals and small hospitals, your bill never comes to 50 lakhs. So majority of your cases today will be tried in the district commission. Unlike in the past, if he had asked for a compensation of say 50 lakhs, then the hearings would take place in the state commission. So I hope you understand the difference that has happened as far as the old COPRA 1986 concerned and the CPA 2019 is concerned. I'll come to how detrimental this is in the further slides as far as the medical profession is concerned. Then again, they have changed the territorial jurisdiction. So what was there in the old COPRA 1986? That wherever that causation of that particular issue is concerned, that the harm is concerned, that means either the seller's office or where your hospital was situated, the territorial jurisdiction would be that area. That means if there is a case in a Bangalore hospital, the territorial jurisdiction will be Bangalore. That was there as far as the COPRA 1986 is concerned. But today in this new CPA, what has been done is it is left to the consumer to decide where he will be putting up this case. So imagine someone who has come from, say, far northeast to Bangalore to get operated in a hospital in Bangalore. And he goes back to his place and he says, I have suffered because of the treatment given by that particular doctor or by that hospital. He has got a right to go and file the case in his local jurisdiction. So what this entitles is that every time there is a hearing, that doctor and his lawyer will have to run to a distant place for that hearing. So this is going to be extremely detrimental as far as we medical practitioners are concerned, because we do not have the time to regularly go for these hearings away from where our place of work is. So this is also very bad. Then there is e-filing provision which is there in the new act, which was not there in the old act. And because of this e-filing, it has become very easy to file complaints in the CPA. The patient or the complainant can sit in his house, his residence, and file this complaint against you. He does not have to go to the consumer court to file a case. So it becomes very easy for him to file a case, and therefore the number of cases have also increased. Then there is something called the Central Consumer Protection Authority, that is the CCPA, who is a regulator which is brought into this new CPA 2019. And a lot of powers have been given to this CCPA. We will come to that afterwards in the further slides, which was not there in the old COPRA Act. False misleading advertisements was not mentioned in the old Act, but now it is mentioned in the new Act. And this is also, let me tell you, as far as the hospitals are concerned, as far as, you have got your X-ray clinics or anything. And if you are now to some extent, as per the new NMC Code of Ethics is concerned, which will be coming very soon now, to some extent you are allowed to advertise. But if there is a false or misleading advertisement, the consumer can definitely pull you to the court. Then unfair contract trade practices, I told you what is unfair as far as we are concerned. And because of that also, that means if you're not giving your bills properly to the patient, or, proper consent is not taken from the patient is not told about whatever you're doing in details, then he can sue you in the consumer court. Another aspect, which is again, I think, personally feel that it is bad, is that appointment of the forum and the commission has now been placed under the central government and the state government. So the district forums and the state forums will be formulated by the state government, and the central forum or the central consumer commission will be formulated by the central government. This was not so. Judiciary under the old Act of 1986 had a significant role to play of who would be sitting as the judges as far as the consumer courts are concerned. So this is again going to be very bad, because when there is a judiciary sitting, he understands what are the points under the judiciary, which come as far as the medical profession is concerned, which will not be so if there are non-judicial and non-medical people who will be sitting in the judgment as far as the state and the central state district state and the central commission is concerned. Video conferencing, of course, has been allowed, which was not there in the old act. Now this again is a little bit helpful as far as the medical practitioners are concerned, because as I said, since the jurisdiction, the territorial jurisdiction is left to the consumer to decide. If it is far away from your place of practice, you can always come on video conferencing whenever there is a hearing. But let me tell you, my even sitting in the Maharashtra Medical Council, where we used to hold hearings online also. Hearings online is not very satisfactory as far as the doctors are concerned, because many a times what happens is maybe your connection is not proper. What you are saying or putting forward in front of the court may not be very, easily heard by the judge. And because of that, there may be some problems which are there. So we always find that physically going for that hearing is always much better than trying to do it on video conferencing. Though the advantage is that you do not really require to go and sit in the court whenever there is a case against you. So let us see what exactly a few things which have come new over here. The settlement is concerned. So what do you mean by settlement? That during the course of the hearing, if both the parties feel that they can go for mediation proceedings in regard to the issues in the suit or proceedings, or some of the issues, and includes a written agreement between the two parties. That means the two parties will sign that they want to go for a mediation. Only when both the parties are willing, it can go for a mediation. If any one of the parties says no, they don't want to go for a mediation, the courts cannot force you to go for the mediation. Then it will go for a regular hearing under the consumer court. And once you sign that, the mediator will be sitting. The mediator again will be appointed by the court. The mediator will be sitting and hearing to both the parties, and the mediators shall come to some, ultimately to some understanding between the two parties, and he will give the report to the commission. The commission will then go through the report, call both the parties, and if both the parties are willing, whatever has been said by the mediator will be, passed as a judgment by the commission. So this is a good point to some extent when there is actual gross negligence which is there as far as we are concerned, because then instead of going to the judge, who sometimes give very, very harsh punishments, monetary punishments, a mediator, there you can sort of, I wouldn't say haggle, but at least come to some understanding with the opposite parties of what would be the amount of compensation to be given. Then compared as unfair trade practices, I've already told you, giving the receipt of bill of whatever you have done, or disclosure of personal information. If that is not there, then if you do that, then again the person can pull you to court, which was not there as far as the old COPRA Act of 1986 is concerned. So get into the habit. Even if you don't hand over the bill to the patient, you prepare the bill and keep it with you, so that tomorrow if someone asks you, you can say that the bill was prepared. That you can definitely do. So let us come to the jurisdiction of the district commission. Again, very, very important change has happened from the old CPA of 1986. The district commission shall have jurisdiction to entertain complaints where the value of the goods or services paid is less than 50 lakh rupees. So as I have told you, already explained to you, in the old act, it was the compensation demanded by the patient which would decide if he could go to the district court, state court, commission, or the national commission. But today, the value of the goods is what is going to be taken as far as the district commission is concerned. So because of this, majority of the cases will go to the district commission. 99% of the medical cases will go to district. But the unfortunate part about this is that because your billing is less than 50 lakhs, it goes to the district commission, but the patient or the complainant has got a right to ask for 1 crore rupees, again, which will be heard by the district commission, which was not so in the old act. It used to go to the higher commission. So understand this subtle difference which is there concerning value of the goods and amount of compensation demanded. So amount of compensation demanded does not have any mention as far as where and which court would hear your complaints. So it is 50 lakhs district commission, from 50 lakhs to 2 crores is state commission, and above 2 crores it will go to the national commission. Though the act was saying something different, but as I said, there has been an amendment to that act also, and because of that, they have brought it down, because they found that if you put 1 crore as district commission, which was there in the original act, no cases would ever go to the state commission or the national commission. So therefore, they brought it down to 50 lakhs. So if there is an appeal, if you find that the case is going against you, the judgment has been given against you, what can you do as far as the Consumer Protection Act is concerned? So if there is an appeal, then what in that against the whatever decision has been given by the state commission, I mean by the district commission, then you have got 45 days to go higher up to the state commission, right? So you have within 45 days, you are supposed to go to the state commission. Otherwise, the judgment given by the district commission comes into play. But which was not there in the old COPRA 1986 is that if you are going to go to the state commission, you have to deposit 50% of the amount which was granted by the district commission. So understand this bad point that has come, that if the hearing takes place in the district commission and the district commission says, yes, a compensation of 60 lakhs has to be given to the patient, you don't agree with that, you go to the state commission, but for you to file in the state commission within 45 days, you are supposed to deposit 50%. That means 60 lakhs, 50% is 30 lakhs. You will have to deposit in the manner which is prescribed. How many of us can really afford to give, say, 30 lakhs, 40 lakhs as a deposit amount of 50% if we want to go to a higher court? So this is something I think which is again extremely bad as far as the medical profession is concerned. Not only that, if you have agreed for a settlement by mediation, there is no way that you can go for appeal in the higher court. So if your lawyer or you decide, yes, it is better that we go for mediation at the district court level without going for hearing in the district commission, be sure that you will not be allowed, if the order is passed against you, what you do not like, there is no way that you can go to the state commission as an appeal. So your case stops there at the district commission if you are going for mediation. Then if you do not like the judgment which is given, means you or even the patient does not like the judgment given by the state commission, then you can go higher up to the national commission. And that is again within 30 days after the judgment of the state commission. But the difference over here is that the patient can go to the higher court without having to pay a pie from his pocket, whereas we as healthcare providers will have to deposit 50% of the the money that has been granted by the district commission or the state commission before we can go to the national commission. So the onus is again on us to pay that money, but the patient can go without paying a pie. He can go to the higher courts without having to spend any more money from his pocket. So this is again, I think, which is very, very bad and which has to be fought at all levels, especially, we are doing that in IMA. I'll come to the last slide. I talked the last slide, what exactly we are doing at the central IMA level. Another aspect I said that who would be sitting as far as, the consumer court judge is concerned. In the old one, it was said that in the district forum, it would be a district judge. And normally, a retired district judge or someone like that used to be sitting. But what they have added over here is that a person who is or has been or is qualified to be a district judge. That means he has no experience as a district judge, but his qualification is there to be a district judge. He will be sitting in judgment as far as the district commission is concerned. I think this again, as I said, is a little bit problematic for us, that the state governments and the national governments have got the powers to appoint the judges as far as the consumer courts are concerned. Then again, if that president has been appointed, and of course this person would be the president. If the president is appointed, the central government by a notification makes rules to provide for the qualification, term of office, resignation, and removal of the president and members of the district forum. That means all the powers now again has been centralized under the central government, as far as which was there, the powers were there with the state because of the federal system of India. That has been taken away completely. So this is something new again. A structural change has been done as far as the CPA 2019 is concerned. In the old one, you only had the district commission, the state commission, and the central commission. Now there is something called the district council, state council, and central council. They are basically advisory type of councils which will be giving advice to the government to if they want to make any changes in the CPA in the future, and the new rules to be brought in and all that. And the other end is the commission which would be hearing the case. That will be the district commission. I've already told you what is the jurisdiction of the district commission, state commission, central commission. And if you don't like anything that the central commission or the judgment given by the central commission, of course, you can go to ultimately to the Supreme Court. A new addition is the central part, which you see as the Central Consumer Protection Authority. So this authority, again, the central government will formulate this authority. The powers of this authority will also be decided by the central government, and they have been given sweeping powers as far as which is on side of the consumer as far as this authority or CCPA is concerned. So what they will do, they will protect, promote, enforce rights of consumers. So it is going to be completely one-sided and prevent violation of the Consumers Act is concerned. Unfair trade practices will be prevented by them. Then, of course, misleading advertisements, false advertisements, they will take cognizance of that. And what is going to happen is this CCPA will take suo motu action. That means even if there is no complainant over here, they can take suo motu action if they find that the advertisement there is misleading. Now, this is for all aspects. I'm not talking only for medicine, but for all aspects. But they can, suo motu powers have been given to them to take action against them. And the worst part is that the punishments that they can give is imprisonment up to 6 months or a fine, which may extend up to 20 lakh rupees or with both. I think this power which is given to something, though it is a civil court, it is below the civil court as far as the consumer court is concerned. But the power for you to, to put someone in jail, especially as far as we medical people are concerned, which was there only in the criminal negligence, which was not there even under the civil negligence or with the state councils, the medical councils. Now, this power of jailing you, one more authority this power has been given to one more authority, and that is this CCPA or the Central Consumer Protection Authority. Again, this is a little bit detrimental as far as we are concerned. So looking at the whole scenario, what is the critical appraisal as far as this is my personal views which are concerned? So one thing is the appointment of the members of the commission is very worrying, because that powers have been given to the government to appoint and it has been taken away from the judiciary. Entertaining complaints registration at the consumer's place of choice will be detrimental, because every time there is a hearing, you will have to run to some remote place, because he can go to his district, which may be a remote district, maybe about 500 kilometers, 1000 kilometers away from where you are practicing, and you will have to continuously attend that. Telemedicine again has been brought under the ambit of this. So if a patient again who is far away from you, who comes to you for telemedicine, he is far away and he cannot physically come to you. So he takes your advice on telemedicine, and then if he finds that something wrong has happened, he can file a case again where he is sitting. So the convenience is for him to file wherever he wants to do, and it is going to be very inconvenient for us to go and appear in all these courts. E-filing of complaints has become very easy, and therefore the number of complaints which have been filed are also increasing day by day. Video conferencing is something which is good as far as we are concerned, because if we cannot make it to that place because of a busy schedule, we can at least be on the video conferencing, so that ex-party decisions are not taken against us. The pecuniary jurisdiction, I have gone in detail as far as that is concerned, is very, very detrimental for us, because today, depending on the billing, he can file under the district court, but when he files under the district court, he can go up to 1 crore, where he can, ask for 1 crore at the district court level itself. Then, of course, the penalty remains the same, though they have increased the pecuniary jurisdiction. Right from 20 lakhs, the district, the hearings have been increased to 50 lakhs. 10,000, which was there for frivolous and false complaints in the old COPRA, remains in this new act also. And what will happen that we have been fighting, IMA has been fighting for either removing us from the CPA Act or at least capping the compensation. Instead of this, what is happening with this new act is the number of cases which are being filed is increasing day by day. 99% of the cases will be filed in the district commission, which is very conducive to the complainant. There is something called as deemed admissibility. That means if someone files a case, even online, with the district forum, till now what used to happen, unless it is accepted by the district commission, the hearing would not take place. But now, if 21 days are over, it is taken for granted that it is deemed admissible. That means the case has been admitted. Plus, in the consumer court, up to 5 lakhs, there is no fees to be paid by so the patient does not pay anything from his pocket. But today what is happening is we are finding that exorbitant compensations are being awarded everywhere, because by increasing the pecuniary jurisdiction of consumer commissions, the Act de facto accepts that compensation up to and above 2 crores can and should be asked for and awarded. So this is an indirect way of telling that you can go up to that extent also. So this is something which is again going to be very detrimental for us. Now, what has happened in the recent case? Recent case, the lawyers went to court, to the Supreme Court, and the judgment was given by the Supreme Court that lawyers do not come under the ambit of CPA. So if you know what has happened is, that someone went against a lawyer in the district forum where he was found guilty and compensation was awarded. The lawyer went to the state forum or state this commission. The state commission, said that no, he is not guilty by overturning this decision of the district. So the complainant went to the national forum. Again, the national forum overturned the state forum's judgment and said yes, he is guilty. So that lawyer or the bar of Indian lawyers, they went to the Supreme Court, and this judgment was given by D.K. Gandhi in the National Forum. They, against that judgment, they went to the Supreme Court. And what did the Supreme Court say? So for the first time, Supreme Court took a somersault as far as what they had said in the past, where the doctor as a profession was brought under the ambit of the Consumer Forum. Here they said that the legal profession as professionals are exempt from legal proceedings for offering faulty services under Consumer Protection Act. Now, medical profession are also professionals, but they have been brought under the act by the Supreme Court itself. And here, unfortunately, the Supreme Court says that the legal profession, which is again a profession, is exempt from the legal proceedings. So what exactly the court said was the act did not intend to cover professionals. Then why did the Supreme Court bring the medical professional under the act itself? So what they said was the court opined that any interpretation marking the scheme of the act or the preamble to the act to include professionals within the fold of trade or businesses would be nothing but overstretching the scope and ambit of the act. Then why did the Supreme Court themselves overstretch this scope and brought the professionals under the medical professionals under the ambit of the act? We do not know. Further on, it says that as far as the lawyers are concerned, there is an element of nobility in the profession. Observed that the legal profession stood on a much different footing than other professions. This they said because the VP Shanta case was mentioned over there in front of them. And they said, I think we always thought that the medical profession was the most noblest of professions. But the Supreme Court says that the lawyers are a noble profession. Not only that, this nobility and the word sui generis, which has been used, the legal terminology, means that the law profession is a unique profession unto itself. And these lawyers are considered as intellectuals among the elites and as social activists amongst the downtrodden. And they are one pillar of democracy, and therefore they should not be brought under the ambit of CPA. So see the dichotomy that the Supreme Court has brought into where the medical profession is concerned and the lawyer profession is concerned. They further go to say that by virtue of the Wakalatnama, unless it is signed, they cannot appear for the client. So there is no considerable amount of control exerted by a client over the actions of there is considerable amount of control exerted by a client over the actions of an advocate when he signs that Wakalatnama. Now, what happens in the medical field? For any surgery, any procedure that we do, we always take an informed consent where the choice is given to the patient even to refuse to undergo that treatment or to ask for an alternative treatment which is there. So there also the patient has got considerable amount of control on the doctors. But why are they kept under the consumer protection? I am not really aware. And the nature of contract between the advocate and their clients is of service and not for service, as they have clubbed the medical profession into the CPA, saying that the medical or healthcare profession comes for service, whereas the advocates come under of service category. So, sometimes as you say that you do not understand how the court acts, so that this is what has happened. But luckily for us, they have said that they would be writing to the Chief Justice saying that there should be a rethink as far as the VP Shanta case is concerned, where the medical profession has been brought under the CPA Act, and we have taken cognizance of that, and IMA has gone to court and filed its petition in the Supreme Court, taking advantage of mention of the medical profession by these judges, where they brought the lawyers out of the ambit of CPA. And let us hope that better sense prevails and the Supreme Court, gives us the same type of judgment as they have given to the lawyers. Now, what can save, as of now, we come under the medical, the CPA Act. What can save us is, and this I think all of us should take into consideration, that even the CPA talks about the Bolam test. And the Bolam test, what it says, that there cannot be negligence if you possess the adequate skill of what you are practicing, you exercise reasonable care while performing this skill, and mere negligence will not make out a case of compensation against the doctor, but negligence should be a direct cause of the injury to that patient. So mere negligence, if it has not caused any injury, will not come under the negligence aspect. So these can be the 3 points that can save us tomorrow also, whenever there is a case filed against us. So what needs to be done by all of us as medical professionals? What we need to do is, we have to encourage all our members against whom a case has been filed in the consumer court, that all new cases of medical negligence filed in consumer court should take preliminary objection, claiming that doctors are not covered within the ambit of the CPA 2019. That should be a preliminary, very first objection should be over there. Because the Parliament objective was there and it is there, the evidence is there for us to exclude healthcare from the ambit of CPA 2019 as declared by the minister on the floor of the House. And we should pursue these preliminary objections in appeals till the Supreme Court. And IMA headquarters is willing to help, and I think the state IMA will also help such individual doctors to go right up to the Supreme Court, so that we can be brought out of this ambit of CPA. So the unity of doctors is today's need to stay out of the CPA, as the fate of the doctors is in the hands of my lords, that means the judges. How to interpret this new act, as legislators have already shown their clear intention that they do not want the medical profession or healthcare profession to be under CPA. So now it is left to the judiciary to interpret this constitutional. So again, we are back into the Supreme Court, and our, the whole future is in the hands of the Supreme Court judges. So thank you very much for the patient hearing. I hope I have been able to solve some of the problems that people have in mind, some questions which they have in mind as far as this new CPA Act 2019 is concerned. Thank you.
So thank you, sir. Thank you, Dr. Shivakumar Utture, sir. We have got around 3 questions in our chat box. Number 1, by Dr. Saranavanavel. Is there any punishment for the consumer patient for the wrong allegations?
Yeah, I already said that 10,000 is there, but that is left to the court to decide. And normally we have found that the courts are always, or the judges are always on the side of the patients, because it is the patient who has suffered, who has filed the case against you. So very rarely you will find that the judges have ever given this punishment of 10,000, and the 10,000 figure has remained even in the new act. No other punishment is there as far as CPA is concerned.
And one more thing, the second question is there any time limit for the patient to file the negligence case in the consumer court?
Yeah, it is 2 years. 2 years is there. But, there is something in one or two of the judgments, that 2 years can be not from the surgery or the procedure done, but 2 years can be also, and that is again left to the interpretation by the judges, 2 years from when the patient has understood that he has suffered because of that procedure and this. So that gives again a big period for that patient saying that I just came to know that I am suffering today because of what that doctor has done or that surgery which has been performed say 5 years back, and the courts may allow this to be taken up in this consumer. But what is written is that it is 2 years period has been given.
And there is one more thing is there. So one more third question, that is Bolith will come soon, and any replace Bolam's test happening in the West.
Now, see, Bolam still remains as in all the courts, which will. I hope you're asking me about the Bolam's test that is there.
Bolam's test only.
Yeah,
Sir.
it's all there. But subsequent to the Bolam's test, there's something called the Bolitho also, which has come. So what Bolam's test says is that whenever you're talking about or you're hearing a negligent case, it must be referred to a expert panel of doctors who will tell you if there is negligence or not. As far as Bolam's was concerned, whatever report was given by this expert panel of doctors was accepted verbatim by the courts. But then Bolitho came into place after that. And what Bolitho says is that even if some report has been given by this expert panel of doctors, it is left to the judiciary to decide if that report should be taken on record or not. So again, the ball is in the court of the judges, and the powers have again been given to the judges under the Bolitho test.
Thank you, sir. And there are no other questions in the chat box. If there are any questions from our delegates who are there attending, they can raise the hand. Maybe two or
Thank
three.
you, sir. Dr. Veerbhadra here. Very nice presentation, sir. My question is, how do the judges calculate the amount of compensation?
See, there are two ways that they are calculating. Number one is, of course, the suffering that that patient has. So that is left to the judges to decide how much compensation to be given as far as the suffering is concerned. And the other, which we are seeing nowadays being, where huge compensations are given, is that especially if there is a death of that patient, they calculate how much the patient would be earning in his lifetime if he was alive, and accordingly they will give you the compensation. See, this is very unique only to the healthcare sector, because in any other consumer cases, say industries or shops or instruments or anything, what if you have taken a fridge and there's something wrong in that fridge, at the most what the court can say is you replace that fridge to that to the person or that company or something. In medicine, there is something that if there is a death cause, then suppose, and that is in the classical Calcutta case, if all of you know, Amri case, there crores was given to that, that lady, taking into account how much she would earn during her lifetime if she was alive. So this is the sad part, and now it has become, as I said, so easy, because these judgments will be given primarily by the district courts, which is a lower court. These crores were being given by the national forum before, because when you ask for crores, it used to go to the national forum. But today, even if you ask for crores, if your billing has been less than 50 lakhs, it is going to go to the district court, and the district court is going to decide what is the compensation. And if you have to go higher up in appeal, you will have to, suppose he says 1 crore, you have to go pay 50 lakhs has to be paid upfront before you can go for a hearing to the higher court. So these are the bad things that have come into the new CPA, and that's why right in the beginning I said that the new CPA 2019 is worse than the 1986 CPA as far as the medical fraternity is concerned.
There is one more question in the chat box, sir. What about visiting consultant does any complication in a hospital? Who is responsible, whether hospital owner or the treating doctor?
See, what happens is, basically, I'll tell you what lawyers are doing nowadays. Lawyers tell the patient, you file a case on everybody. Sometimes even the nursing staff and everybody, they file the case against them. So it is filed against the doctor, it is filed against the hospital, it is filed against the owners of the hospital. Everybody it is filed because they say, let the courts decide who has to give you the compensation and what percentage of the compensation should be given. So in that again, famous Amri case again, the compensation was divided amongst the hospitals and the doctors percentage wise. And that of course, again, it is left to the, judges to decide what to do.
There is one more question, sir. What about any complication? Okay, whether government doctors come under CPA Act as the services are free in the government hospital?
No, sir. You are paid by the government because I was in JJ Hospital as a professor, so I know there have been consumer cases filed against doctors over there. View Andre is over there. So what they say is, whatever you have been paid comes from the taxes which are taken from the citizens, which makes them as consumers. So you cannot say that it is absolutely free of cost. In private, you can, there is another thing in private also, which is there, which everybody should understand. That if you are seeing free patients in private, yet you will come under the consumer if one of these patients complains, because all your patients are not free. See, you are charging some of your patients. So you will not have that, leeway of saying that your patients are free. So every one of us will come under the Consumer Protection Act, even if we are giving that particular patient free of cost.
What about the hospitals run by the trust, sir? Trusts.
Even there, the trust hospitals also charge. See, for making a paper, maybe that minimum 5 rupees, 10 rupees that they are taking for that OPD paper, that also the consumer is paying. So how can you say that you are free? Man, this is not my say. This is what the judgments have been there as far as the consumer courts are concerned.
Is there any way to fight that doctors won't come under consumer laws?
Yeah, we are doing that. As I said, the National IMA has taken cognizance of the two judges who have said that they would request the Chief Justice to relook at the VP Shanta case as far as the medical profession is concerned, to be brought under CPA. And under that, we have again filed a petition in the Supreme Court. Let us hope. I don't know what will happen. You have to remember that when the judgment was given by the judges themselves have been past lawyers also. So they have said that the lawyers are a unique profession. I don't know how far they will take doctors as a unique profession, keep us out. It is all left to the judges in future.
And there is a new question which has come up. That is any burden of proof lies whether it is with the patient or with the doctor, sir?
No. In a civil case, the burden of proof is always with the patient. In any civil case. So in the CPA is also a civil case. The state medical councils are also civil. Civil courts are also civil. In a civil case, it is the burden of proof or to prove that the doctor is negligent lies with the patient. It is only in a criminal case where once the case is filed against you, the doctor has to prove that he was not criminally negligent. So it becomes the other way around. But CPA, the onus is on the patient.
And I think that's all the questions in the chat box, sir. If there are any other questions, we can take only one or two, as it is already, we have crossed 10 to 25 at least.
Yeah. Prasad.
Yes.
Finally, you mean to say that one all in the hands of the judge?
Yeah, that my last slide said that. It is in his honors. What happens?
So does the
All the
government hospital come under consumer?
Yes, sir. Nowadays, government hospitals are also charging you for the OPD papers. At least in
That is what.
Maharashtra, they are charging you 5 rupees. So under that, with that 5 rupees, you come under consumer.
Yeah, even X-rays, all procedures also been charged.
Yeah.
And there is a final question, sir. How many years we need to maintain the documents, medical documents, whether it is MLC or non-MLC?
Well, see, as far as medical documents is concerned, the old MCI Code of Ethics, which is existing as of now, 2002, and even the new Code of Ethics, which will be very soon will be notified, the NMC Code of Ethics of 2023, it talks about only indoor papers to be kept for 3 years. But the difference in between the old code of ethics and the new NMC draft, which is there, is that the old code says 3 years from when the patient has seen you for the first time. But the new draft says 3 years from when the patient has taken the last consultation with you. So if there is some chronic patient, say hypertension, diabetes and everything, he may have come to you 5 years back. Okay. But he was taking treatment right up till last year. Then he is allowed to file a case. I mean, you are supposed to keep that papers for 3 years from the last date from which the patient has taken your consultation. That is the difference. As far as OPD patients are concerned, it is always a good thing to keep a duplicate of the OPD case papers, though the old code of ethics, which we are governed under that code of ethics, or even the new NMC code of ethics, does not talk about OPD papers at all. But then if you have your OPD papers, this is especially because there are some cases which I have heard in the state councils against psychiatrists. There everything is OPD basis they are treating, where the patient has complained against them. Luckily, psychiatrists under the Psychiatrist Act also are supposed to keep all the papers. So he had kept the papers because that what that patient has done, and this is what happens, the patient, when they go to the lawyers teach them all wrong things. Selectively, you choose those papers which are going against the doctor and produce that in front of the council and hide the papers which are, going in favor of the doctors. Luckily, he had the papers with him, so he could save himself. So it is always a good thing if you have even the records of the OPD papers for 3 years. And as far as medical legal cases, different courts talk about up to 30 years and everything. But whenever I give a talk, I always say that your medical legal case papers should be buried along with you when you are buried. Because even if the lower courts give some judgment, that patient can go to a higher court. So you will have to have all the papers ready with you. So don't ever destroy any medical legal case papers for whatever number of years you're practicing. Keep it till the end.
What about the records for children, sir? Should we maintain till they attain?
Yeah. Till they get adulthood. That is there in the act. That's a separate act itself. Not only that, even the birth records you're supposed to keep till that child attains, say, 18. Though we say up to 20 years, you keep that, because at the age of 20, he may find that mentally, he is a little backward because there was no oxygenation during my delivery, and action can be taken against that doctor. These are the unfortunate things as far as law is concerned, but we have to follow that.
Prasad? Prasad? Yeah, ask Pawan to give vote of thanks. Pawan, are you there?
Thank you, sir. I, Dr. Pawan Patil, sir.
Pawan?
Propose vote of thanks. Dr. Pawan, sir.
Pawan has gone. Pawan has gone for dinner. He couldn't.
Yeah. Yeah. Prasad.
Sir.
You can you yourself can render vote of thanks.
On behalf of IMA KPPS from IMA Karnataka State Branch, so we are happy that we had this session. Especially, it is a brainstorming session, and it was told in very much detail by our Dr. Shivakumar S Utture, sir. So all your whatever the experience you have had for so many years, definitely you have given it to us, and many of the questions you have answered to us. We really thank you, sir, for the wonderful deliberation, and also the illustrative, whatever the slides are also very informative and also educative for all of us. And at this, definitely I need to thank all our IMA KSB office bearers, especially our president, Dr. V.V. Chinirwala, sir, Dr. Suri Raju, our Honorary State Secretary, sir, and our Shankar Narayan, our Honorary Treasurer, and our Chairman, IMA KPPS, Dr. Madhusudan Karimur, sir, and all our previous and past presidents of IMA KSB, office bearers of various branches in Karnataka, and all the leading professionals who are there, even joined from other associated medical specialties today. So I thank all of them for attending this wonderful session. It is a first of its kind which has taken place, especially on the Consumer Protection Act. Still, it is a burning issue among all of us, and there are so many micro acts like that which we couldn't understand. today, sir has made us to understand all this, even minute details of the Consumer Protection Act. And we are very, I think everyone of us now we are aware, and definitely we are going to carry this message to all our colleagues and as well as for the hospitals where we are working. Thank you, one and all. Who are
Thank you,
attending.
sir. Thank you, Utture, sir.
Thank you.
On behalf of IMA KSB, I thank Pawan Patil also for coordinating well with the sir and making this happening. Thank you, sir. We look forward for a few more lectures and knowledge sharing from you, sir. Thank you very much.
Thank you. Thank you.
Sir, thank you, sir.
Thank you, sir. Thank you, sir.
Thank you.
Good night.
Thank you all.
Thank
Yeah,
you,
good
sir.
night.
Thank
Good
you.
night, sir.
Good night. Good night, all.
Great, sir.
Yeah.
Thank you, sir. Thank you.
Good night.
Yeah, we shall take a leave.
Thank you.
Oh,